Ladies and gentlemen, for those members of the profession and various judges of the Federal Court and the Supreme Court who have not been at the conference today, welcome. This public lecture is also part of what is the fourth full meeting of the Standing International Forum of Commercial Courts, whose meeting is being jointly hosted by the Federal Court and the Supreme Court of New South Wales. In the distinguished people with the yellow lanyards are delegates and from 30 different jurisdictions, and we have another 80 in total in person and another 50 or so online. It's a very significant gathering of senior international judges who have already been welcomed, but I welcome you to this, our Banco Court, the ceremonial court of the Supreme Court. The lecture we are about to hear, the keynote addresses the role SIFoCC, the organisation which is meeting, is playing and can play as part of a cornerstone of a transnational system of commercial justice. Our lecturer, well known to all the delegates and probably well known to many of the members of the profession and the judiciary, the local judiciary in this room, is Chief Justice Menon of Singapore, who is on the verge of clocking up a decade as Chief Justice of Singapore. For Australian judges, that's a very significant milestone because it typically qualifies one for a pension. But he seems to have so much energy, I do not see retirement in the wings. He is, as I've said, been Chief Justice for almost 10 years. He highly qualified initially from the National University of Singapore and then from a law school called Harvard in the United States, and then in private practice, both as an attorney and an advocate, then a stint as Attorney General of Singapore. So he's uniquely placed to know how to extract funds from the government to provide him with all the technology he has been proselytising about, and other courts have been scratching their heads saying it's all very well, but how do we get it? Who pays for it? Anyhow, he is a dynamic judicial leader, prodigious contributor to the global judicial dialogue, which is increasingly important in a world which is needs the rule of law more than ever. It's my very great pleasure to invite him to deliver the keynote address.
Chief Justices, judges, distinguished guests, ladies and gentlemen, good evening. And to those of you joining us remotely, warm greetings from all of us in Sydney. Let me begin by acknowledging the Gadigal of the Eora Nation and pay my sincere respects to the elders, past and present, and to all Indigenous Australians. Before I move to my substantive remarks, I want to record my deep appreciation to Chief Justice Andrew Bell for his kind and generous introduction, and also to him and to Chief Justice James Alsop for the warm hospitality that we've all enjoyed in Sydney, and for making it possible for us to be here today, because it really is excellent to be able to see and meet so many of you in person again. The Standing International Forum of Commercial Courts, or SIFoCC, was established at the initiative of Lord Thomas in 2017, when he was Lord Chief Justice of England and Wales. And in the years since then, it has grown in its membership, but also in the ambition of its projects and its conferences. Today, it is the largest gathering of commercial courts and judges from around the world. all united in their mission to deliver justice to parties engaged in transnational commerce. I congratulate Lord Thomas, Mr. Justice Robin Knowles, and the Secretariat for the tremendous work and for all their efforts in bringing about the remarkable growth of the forum within such a short period. This suggests that it does have a vital role to play. Those who participate in SIFoCC's programs are all busy people, and they would not continue to make the effort unless they believed it was worth doing so. I suggest today that having gotten this far, we should now look ahead to how we might conceptualize the next chapter of the SIFoCC journey. My principal suggestion this evening is this: transnational commerce remains a key driver of global efforts to sustain growth, alleviate poverty, and improve lives. And given the extent to which trade today is truly transnational, the need of the moment is a commitment to develop and sustain a transnational system of commercial justice. And I think SIFoCC is exceptionally well placed to drive this effort. And later in my speech, I will seek to illustrate this with reference to the themes of this year's meeting, which reflect some of the most important issues faced by those of us engaged in international commercial dispute resolution, or ICDR. I developed my thesis in 3 parts. First, I will explain what I mean by a transnational system of commercial justice, and I will argue that such a system is already in place, albeit as a work in progress. Next, I will outline why and how we should work intentionally to enhance the development of that system. And finally, I will outline some ideas for how SIFoCC might evolve to play a central role in this effort. At the heart of transnational commerce lies the phenomenon of globalization. While it is impossible to speak of globalization today without acknowledging the many challenges it faces, I believe, as I have argued on a number of recent occasions, globalization is here to stay. This is not least because the greatest challenges that confront us today are global challenges that demand transnational collaborative responses. These include geopolitical instability, global health security, the erosion of truth, stagflation, structural income and wealth inequality, and the climate crisis. None of these can be addressed by our retreating into domestic silos. And addressing them will be that much harder if we cannot maintain a healthy flow of transnational commerce to sustain economic growth and thus offer the hope that we can alleviate poverty and optimize the returns of our limited resources for the benefit of all. Much can be said for building a more sustainable vision of globalization than what we have hitherto seen. The precise vision we ought to embrace for the future will be a matter for contestation, discussion, and experimentation for years to come. Nonetheless, I think we can all agree it must be a vision of a globalized, interconnected world, and not a fragmented one made up of insular blocks standing apart. I outlined aspects of this vision at a lecture I delivered in Perth earlier this year, and this evening I want to develop those points further. Whatever shape the future of globalization takes, the law will remain a critical part of the infrastructure of commerce. This can be traced back to early civilizations, but a more proximate starting point for understanding the law's role in transnational commerce is the law merchant, or the lex mercatoria, a common body of rules and customs widely adopted by merchants in Europe around the Middle Ages. This was a system of law where rules were applied throughout the trading region in a broadly consistent way by means of a network of courts and informal adjudication that prioritized speed and efficiency. From the 17th to the 19th centuries, those rules were gradually assimilated into national legal systems, and so they largely lost their transnational character. As a consequence, international commercial law today is often thought of less as part of a coherent system and more as a hodgepodge of rules from different sources. I suggest that a renewed focus on a modern notion of a transnational system of commercial justice will be essential in a globalized world. To explain this, it'll be necessary to outline what is meant by a transnational system of commercial justice. At its most rudimentary, a legal system is a public framework of laws accompanied by institutions which make and develop those laws and which seek to interpret and apply them in a broadly consistent manner, thus offering a basis upon which differences can be resolved fairly. At a domestic level, we all know what this means. But ever since the nationalization of the Lex Mercatoria, it has been less obvious what it means in a transnational setting. We do not seek a supranational legal system, but we can effectively achieve many of the benefits of having such a system to facilitate transnational commerce by seeing the many discrete players and processes that do regulate aspects of commerce as though they were part of a system, at least on a conceptual level. But why should we do this, even assuming it were possible? At the most fundamental level, it is because legal differences and uncertainty increase transaction costs and hamper growth. And these costs will only increase with new risks emerging in areas such as artificial intelligence and data privacy that inevitably will have a transnational impact while also necessitating new ways of regulating modern business. In addition, cross-border business activity inevitably leads to cross-border commercial disputes, and this inevitably adds another layer of heavy cost. A focus on fostering a transnational system of justice would prioritize the convergence of commercial laws where possible and the minimization of the inefficiencies that inhere in transnational dispute resolution. Now, this seems a mammoth task, to be sure, and it seems to be made even more difficult to navigate by the fact that different components of it have been worked on variously by different stakeholders over the course of the past few decades. Yet, somewhat ironically, I suggest it is because of the steady work on so many fronts that the transnational system of commercial justice is already in existence as a work in progress. Let me briefly illustrate this with reference to two of its facets, procedural law and substantive law. Beginning with procedural law, the exemplar for meaningful convergence is the set of rules of private international law governing arbitration agreements and awards. At its center are the 1958 New York Convention, which with 170 parties and counting, has created an almost universal regime for the enforcement of arbitral awards, and the UNCITRAL model law on international commercial arbitration, which is very widely adopted today. These instruments create a robust and vital framework for managing the resolution of disputes by channeling them to the right avenues and thus avoiding the unnecessary relitigation of issues by foreclosing the review of arbitral awards on their merits. Such a perspective rests on a systematic rather than a court or jurisdiction-centric approach to transnational commercial justice. And there have been long-standing efforts at achieving convergence in substantive law, such as through the Convention on Contracts for the International Sale of Goods, or the CISG. Looking ahead, we can expect to face an ever-growing set of legal issues that have an inherently transnational character, such as those arising from our responses to challenges like climate change and global public health. For example, disputes arising from projects under the Green Climate Fund of the UN Framework Convention on Climate Change have already come before arbitral tribunals. These and other disputes may turn on the commitments made under the Paris Agreement, under national rules or policies made to implement those commitments, and the actions of individuals and businesses in response to these instruments. Another example is the Chancery Lane project, which has contributors from 113 countries. This has published a set of template contractual clauses which can be inserted into a range of business contracts to mandate the pursuit of climate-related priorities. If the project is successful, it will soon fall to arbitral tribunals and commercial courts to interpret these clauses when contractual disputes arise. The legal norms arising from these decisions have the potential to become the transnational norms that will guide the greener conduct of global commerce. We will significantly handicap our ability to mount a coordinated responses to such global challenges if we were to approach these disputes in an ad hoc fashion or in national silos, instead of striving to achieve broad and thoughtful consistency in the approach we take to the interpretation, development, and application of these norms, or at least to ensure that any divergences are principled. None of this means that the entire corpus of commercial law must be the same everywhere. Not only would that be unachievable, the laws of each jurisdiction reflect a compromise between the competing political, social, and economic realities within that jurisdiction. But even so, in some select areas, we can attain uniformity. In others, we can pursue meaningful convergence. And in the remaining areas, we can at least aim to acquire an understanding of our principled differences. And for the reasons I've just explained, these are worthy goals for us to pursue. To achieve them, I suggest we should see the body of laws that govern international commerce and ICDR, as well as the institutions involved in applying them from the perspective of a system, rather than as a mere compilation of rules administered by discrete and disconnected entities. In short, we should seek to develop a modern-day lex mercatoria. The examples I've just discussed also illustrate the importance of what I call the drivers of meaningful convergence. In domestic law, we take it for granted that the law is made and refined by legislatures and courts. On the international plane, there is no single authority that has responsibility for the development of the law. Instead, convergence is driven by a multitude of stakeholders with varying degrees of coordination among them. Prime among these are international organizations such as UNCITRAL, which promulgate international instruments such as the Model Law and the CISG. But another key driver of convergence is international judicial dialogue. And this takes place on at least two levels. First, through the means that is especially well known to the common law, the publication of judgments which are then read by practitioners and by courts in other jurisdictions. The cross-citation of authorities across different jurisdictions is an important way in which we ensure that the law develops across borders in a manner that is cognizant of other pertinent positions and considerations. And second, and much less frequently appreciated, is direct communication and collaboration between judges across jurisdictions. I suggest that the transnational system of commercial justice benefits tremendously from such exchanges, which are an often overlooked source of strength for a court system. It helps judges keep abreast of legal developments emanating from their colleagues across the world and provides them with a sounding board for their own thoughts and ideas. And just take a moment to think about what we've been doing all day. This is where we see the genius that lies behind the establishment of SIFoCC as an international community of commercial judges. In the 5 years since its establishment, SIFoCC has already achieved a number of notable feats, of which I highlight just 3. SIFoCC has developed and published a multilateral memorandum on enforcement of commercial judgments for money, with each contributing judiciary explaining the legal position in their own jurisdiction. While the memorandum is not legally binding, it provides clear and reliable information that can give judges much greater confidence in understanding the implications of their rulings in transnational cases and afford litigants the comfort of knowing how they can monetize their judgments. With such a tool, we take a significant step towards achieving meaningful convergence in an area of law of central importance to commercial users. Second, SIFoCC has also published a set of guidelines summarizing international best practices in case management, incorporating the input of judges from more than a dozen jurisdictions. This document provides an excellent starting point for courts to develop their own principles on effective case management, something that emerged as a vital necessity in this afternoon's session, and a particularly important capability for effective commercial dispute resolution. And third, at the height of the COVID-19 pandemic, SIFoCC issued 2 COVID-19 memoranda in which member countries pooled their experiences and the lessons they had learned from how they use technology to sustain the delivery of justice during the pandemic. The remarkable work SIFoCC has already done should, I suggest, be seen as a precursor to a more ambitious goal: an international community of leading commercial judges, international adjudicators, and third-party neutrals, engaging in direct dialogue in the endeavor to develop and refine solutions and responses to the challenges that face all of us in the world of ICDR. Happily, we have just taken the first step in this direction with this year's SIFoCC meeting. I would like to situate the discussions we've had today and which we will have tomorrow within this broader context of developing a transnational system of commercial justice. Our topics of discussion will make a direct contribution towards 2 important facets of this undertaking. First, improving ICDR by having it function more as a system. And second, raising the effectiveness and the capabilities of adjudicators and indeed of the system as a whole. I begin by suggesting that we should first acknowledge the reality that the ICDR system encompasses not only litigation, but also arbitration and increasingly mediation and other forms of dispute resolution. A commercial dispute today will frequently flow across these different mechanisms. To take one example, most complex infrastructure projects benefit immensely from the work of dispute boards, which can dramatically reduce what remains in dispute at the end of the project for that to be resolved by further mediation, arbitration, or litigation. And more commonly, the enforcement of an arbitral award or a mediated settlement agreement will typically lie in a commercial court, sometimes in a different jurisdiction from that of the law governing the arbitration or the mediation. And multiple proceedings of the same or similar matters may arise in different jurisdiction or fora, raising the question of how each should regard the related proceedings in the others, especially where a judgment or award has already been rendered. In these situations, commercial courts will typically be the ultimate arbiters of where the disputes are to be adjudicated and whether recognition should be accorded to the outcomes of those other proceedings. In this way, I suggest commercial courts are akin to the control centers of the ICDR system. There is no single predetermined court that will serve as the control system or control center of any given dispute. Instead, each court has the prerogative to rule on jurisdictional disputes that pertain to the proceedings before it. And it follows from this that we should then strive to develop broadly common approaches to manage and reduce jurisdictional conflicts. The central guiding principle should be to minimize costs and uncertainty arising from the possibility of jurisdictional arbitrage and the relitigation of decided issues within the overarching aim of doing what is just in the circumstances. The rules that the courts have developed in areas such as the enforcement of arbitration agreements, the effect of exclusive jurisdiction clauses, rules for managing lis alibi pendens, should all be understood in this light. And I think we might be surprised as to how much common ground there is on these points among different jurisdictions. Such commonality, I suggest, would be less surprising if we thought of these rules not as a strategy to dominate a contest for turf, but as part of an effort to introduce order and predictability within the ICDR system. In the commentary that opens the SIFoCC multilateral memorandum on the enforcement of commercial judgments for money, the learned authors observe that there is, and I quote, a gradual drawing together of the approaches of the civil and common law jurisdictions, end quote. But they also recognize that the rules in this area are complex and not always capable of generalization. I think the same can be said for much of the law of jurisdictional conflict. SIFoCC offers the ideal platform for meaningful engagement over such issues, and we have the opportunity to begin doing so tomorrow under Theme 4. Perhaps through such a forum, it might be possible to aspire to reach a common understanding of what the principles are and even dare to produce another multilateral memorandum, which would be a tremendous service to the international business community. Adopting a systematic approach would likewise enable us to see commercial courts as playing a vital role in maintaining quality standards for the conduct of arbitration and mediation. In the context of arbitration, courts will have to rule on contests as to the fairness of the process and on allegations of natural justice. In doing so, they strive to strike a balance between safeguarding the integrity of the arbitral process and not permitting disgruntled parties to contrive such allegations just to undo those outcomes, a phenomenon that has led to the coining of the term due process paranoia. Divergence in the jurisprudence of different courts on these standards can cause confusion and compromise the conduct of effective arbitration. And with the increasing adoption of the Singapore Convention on Mediation, commercial courts will soon be faced with similar challenges arising from mediated settlement agreements. One ground for the refusal of enforcement under the Singapore Convention is a serious breach by a mediator of standards applicable to the conduct of mediation. It will fall upon commercial courts to consider and articulate what amounts to such a serious breach. And again, broad consistency across jurisdictions will be equally important here. SIFoCC provides the ideal setting for judges to understand diverse views on how these standards should be calibrated, but to do this, they will need a real understanding of the realities of arbitration and mediation practice. In theme 1 of this meeting this morning, we saw judges and representatives from the other disciplines in ICDR exchanging their perspectives. Imagine the benefits of SIFoCC institutionalizing a regular dialogue on these matters among judges, arbitrators, and mediators to raise awareness and understanding among the key players on all sides with a view towards working to achieve a set of shared perspectives on these issues. I note in passing that this was precisely what Judge Dominique Asher, representing the ICA, in our first session this morning suggested. A second facet of ICDR in which SIFoCC can lead the way is in raising the effectiveness of adjudication and the capabilities of adjudicators. I have in mind new types of issues or challenges that all of us involved in international dispute resolution are likely to face. And again, let me illustrate this with some examples. I begin with the challenge of complexification, which we discussed this afternoon. This is the phenomenon of disputes becoming so factually rich and technically complex that they threaten to become virtually impossible to adjudicate in the traditional ways, because they surpass the ability of any single adjudicator to fully comprehend and analyze the material. Solutions that aim to increase the efficiency of adjudication are important, but they can only take us so far. When faced with a truly complex dispute, an adjudicator will have to find more drastic approaches to downsize it to a manageable scale. And these may include relatively new ideas that might challenge our traditional assumptions, such as representative sampling, bellwether trials, and the use of summary procedures to dispose of lower value claims in large trials. There is immense value to be had if these ideas were studied, discussed, and shared across as wide a community of dispute resolvers as possible. Not only would this promote their acceptability as ideas, but it would also shine a light on mistakes as well as on best practices, and this would be for our collective benefit. The value of seeing other disciplines such as mediation as part of an integrated ICDR system becomes especially evident in this context. Litigation and arbitration tend to be rights-based approaches to dispute resolution, whereas mediation is more generally interest-based. But these are not binary options, and sometimes our interests may lie in moderating our insistence upon our rights. And we can do this by incorporating techniques such as mediation or early neutral evaluation within the adjudication process itself. And this has been done to great success in complex insolvencies. A good example of this was in the collapse of Lehman Brothers, where the mediation protocol adopted by the US bankruptcy court resulted in the settlement of hundreds of cases yielding billions of dollars for creditors. Even where the whole dispute cannot be settled, the incorporation of such techniques can reduce the number and scope of procedural and substantive disputes that the court must rule on. Is it not time for us to engage in these dialogues with our fellow dispute resolvers? Theme 2 of this meeting started precisely such a dialogue. And SIFoCC affords a platform for us to continue that conversation, perhaps with the aim of finding ways to combine our diverse crafts in a shared commitment to better serve those engaged in transnational commerce. And looking further ahead, the global issues that I referred to at the start of my address will be another emerging source of complexification which we cannot afford to leave to be addressed within our jurisdictional silos. The law's response to climate change is a central example, and this can come at a number of levels. First, tremendous investment will be needed as part of the global response to climate change, and many of these will inevitably give rise to disputes that will need to be adjudicated. Second, through the Chancery Lane project I mentioned earlier and other avenues such as counterclaims in investor-state arbitration for damage caused by the investor to the environment, we may have to reconsider our understanding of the usual patterns of legal rights and obligations in transnational commerce. Third, and most significantly, citizens may seek to hold governments and perhaps also businesses directly accountable for their contributions to climate change or their failure to mitigate it. The discussion we will be having under theme 3 tomorrow on how corporate legal responsibility and governance can respond to climate change will be an important start. But I believe it will only be a preface to what will need to be a much wider ranging discussion within the transnational system of commercial justice of the issues that we should be thinking about and the developments that are already afoot as the law responds to climate change. And again, I suggest SIFoCC is especially well placed to be at the vanguard of this effort. Let me pull these threads together with an example of how systematic thinking has informed remarkable advances in the approach to managing complex international disputes in one field in particular, the field of transnational insolvency. The Nortel Group comprised more than 130 companies located in more than 100 countries. Following its insolvency, some $7.3 billion was raised from the sale of the group's intangible assets. The problem was that it was impossible to view these assets as being located in any one jurisdiction or as owned by any one subsidiary. As the Ontario Superior Court of Justice described it, the Nortel Group was, I quote, a highly integrated multinational enterprise with a matrix structure that transcended geographic boundaries and legal entities, close quote. You could apply that to any number of big companies today. The Ontario Superior Court, the US Bankruptcy Court for the District of Delaware, decided to hold a joint trial to determine how to allocate the sale proceeds. Under an agreed cross-border insolvency protocol, joint hearings took place before both courts, with the judge, the lawyers, and the witnesses in each courtroom connected to each other electronically. Outside of the hearings, the two presiding judges communicated directly with each other in accordance with the protocol and were able to determine that they could reach consistent rulings to distribute all the money. This is a stunning example of courts, the parties, and their lawyers taking a systems-based approach to the resolution of a hyper-complex transnational dispute. If the Ontario and the US courts had chosen to act within their own jurisdictional silos, it would have been much more difficult, even assuming it were possible at all, for the group to be wound up in an orderly manner that preserved the value of the assets. Because of cases such as this, many insolvency judges have come to recognize the tremendous value of being able to communicate with one another when handling discrete parts of a cross-border insolvency. In 2016, a transnational group of like-minded insolvency judges came together in Singapore to form the Judicial Insolvency Network and developed a set of guidelines for court-to-court communications that could readily be adopted by courts across the world. These guidelines have been incorporated into the rules or practice directions of a number of courts and have already been used in some matters. Taking an even broader systematic perspective, those in the world of cross-border insolvency have recognized that such matters depend on a consistent, overarching framework being available for their management. To this end, UNCITRAL first developed a model law on cross-border insolvency to this end, and then, seeing that the insolvency of groups of companies posed unique issues of coordination and the need for particular cross-jurisdictional solutions, it published a model law on enterprise group insolvency in 2019 to promote a common and systematic approach to such cases. In these examples, we see the tremendous value to be had in approaching our work from the perspective that we are each components of a larger ICDR system. I began by suggesting how we could conceptualize the system. And while I acknowledge the scale of this vision, I also suggest that many of the foundational elements are already in place. The need of the moment is to dare to go further and reframe the various moving parts, not as discrete elements pointing in vaguely the same direction, but instead as components of a transnational system of justice that regulates cross-border commercial activity. This will surely facilitate the development of coherent and consistent transnational legal norms in many of these diverse areas of procedural and substantive law. And that, in turn, would better serve the needs of international commerce by promoting what Chief Justice James Alsop has called a culture of problem solving that goes beyond black letter law and discrete processes and instead focuses on the sensible and effective resolution of disputes as part of a system. And finally, and most importantly, by sustaining a reputable ICDR system, we also strengthen the global rule of law. All of this shows why it is so important to have a platform such as SIFoCC. Besides building up an international community of commercial judges, SIFoCC can bring together the leading experts and institutions in the ICDR system as a whole. And I congratulate the organizers of this year's meeting, for including representatives from the arbitral and mediation institutions. And I look forward to continued exchanges with them and other players in the space under the SIFoCC umbrella. I suggest that we now look into establishing formal partnerships between SIFoCC and some of the leading arbitration and mediation institutions so as to formalize our working relationships with them. This would recognize and underscore the importance of a systematic approach to ICDR and to the development of transnational commercial law. I suggest that we further consider including representatives from the world of arbitration and mediation in the SIFoCC working groups so as to ensure that SIFoCC's endeavors are developed from the perspective of an integrated system. In the more distant future, we might envisage the establishment of a research unit under the aegis of the Secretariat and the publication of materials that promote the systemization of ICDR. It might see us collaborating with organizations such as the Asian Business Law Institute, the European Law Institute, and the American Law Institute on the development of international commercial law, or perhaps even engaging in dialogue with other bodies actively pursuing the project of convergence. As SIFoCC's memberships and partnerships grow, this will further enrich the ongoing conversation among the stakeholders in the transnational system of commercial justice. This will help ensure that commercial courts and other dispute resolution providers around the world are equipped with the knowledge, the tools, and the practices to support the delivery of justice nationally and internationally. Justice David Barneville spoke for all of us this morning when he highlighted how much we have learned from the conversations that we have had today. We will need help, all the help we can get, to address the global challenges to which the flourishing of the world economy and indeed our collective fates are tied. And SIFoCC promises to be a vital provider in that respect. The vision I have outlined might seem like a moonshot, but I suggest it is a worthwhile goal because there will be many gains to be had from securing such a system that is built on a shared vision and a mutual understanding among judges and dispute resolvers around the world. That such a system might help our world meet challenges as important as poverty and climate change underlines the responsibility on us together to keep this work going. And it is made more exciting by the fact that we have actually already begun our journey. And it has been my privilege to present it to you this evening. Thank you.